Our next panelists are going to speak about the Live-In Caregivers program, challenges and testimonies. Terry Olayta and Maria Deanna Santos. Terry Olayta was born in the Philippines and holds a Bachelor's of Science in Business Administration from the Northwestern University. In 1995, she was elected as the first coordinator of the Coalition for the Defense of Migrant Workers' Rights from over 8 workers' organizations and NGOs to hold the defense of migrant workers' rights. Her activism started 20 years ago when a group of domestic workers, including Terry, organized themselves as the Canada Foreign Domestic Movement. This small body of 20 women fundraised to create a scholarship fund to assist women in financial need. Additionally, with the support of school officials, it launched a fundraising campaign for a dying domestic worker to return to her family in the Philippines. Mrs. Olayta has been an active member of the United Filipino Mothers Association, the Parents, Youth, Families and Friends in Action, the Caregivers Resource Center, and the First Ontario Alliance of Caregivers of Canada. Maria Deanna Santos is an immigration lawyer based in Markham, Ontario. Her interest and involvement in live-in caregiver issues stem from her graduate studies research on human rights and migrant domestic work. She continues to advocate for these issues while assisting caregivers' clients with their immigration concerns. Welcome, Terry and Maria Deanna.
Thank you, Harmy. Good morning, everyone. Okay, so although our presentation will deal specifically with the Live-In Caregiver Program, we do note that we agree with all the advocacy strategies espoused or suggested by my colleague, Ms. Avigo, and all the other previous speakers. And so I will deal, in the first part of the presentation would be to provide a background of the program itself, the Live-In Caregiver Program specifically, and all the challenges faced by participants of this program, and the second part will be a presentation on the advocacy strategies that have been undertaken on behalf of and by the caregivers themselves. So just in case some of you may not be fully aware of the features of the program, the Live-In Caregiver Program, or the LCP, is a hybrid immigration program where within Canada's Immigration Refugee Protection Act, whereby a specific class of temporary foreign workers, namely the live-in caregivers, is given a chance to apply for permanent residence only after fulfilling certain conditions. On its face, it may seem that live-in caregivers are given a special privilege compared to other so-called low-skilled temporary foreign workers who have no clear path to permanent residence. However, it must be noted that the LCP is not a smooth-sailing program, as had been touched upon by the previous speakers, as the conditions imposed on its caregiver participants render them extremely vulnerable to abuse and exploitation. Some of the problematic features of the LCP include, first, the 2-year full-time live-in caregiving work requirement. Regardless of whatever label is given to this program, this requirement alone strongly encourages situations which are very much akin to indentured servitude or even modern-day slavery. In reality, live-in caregivers perform work that Canadians would rather avoid. The work is extremely hard and the pay is extremely low, with very little monitoring, if at all, of the employer's compliance with employment standards. Requiring live-in caregivers to perform this type of work for at least 2 years within 4 years of their arrival in Canada as a condition for being qualified to apply and not even automatically qualify them for permanent residence renders them, as I said, extremely vulnerable to abuse and exploitation. The second problematic condition is the employer-specific nature of the work permit. Like the live-in requirement, the employer-specific permit ties the caregiver to a single employer, which further tilts the balance of power in favor of the employer and against the caregiver. And in relation to this, the requirement for a new LMO, or a labor market opinion, before being allowed to work for another employer, with its accompanying issues such as additional fees and processing delays, discourages the live-in caregivers from leaving abusive employers or even reporting them to the authorities. A third problematic feature of the LCP consists of the processing delays for the LMO applications, work permit renewals, or the permanent residence application itself. These delays not only discourage the caregivers from leaving or reporting abusive employers, but also force them to endure prolonged and very painful family separation. And fourth problematic feature is that the grant of permanent resident status only after completing 2 years of full-time live-in caregiving work is not even guaranteed. Even after years of waiting for the permanent residence applications to be processed, many live-in caregivers and their families may still end up being denied permanent residency due to criminal or medical issues, alleged misrepresentation, unauthorized work, receipt of social assistance, and other supposed violations of the immigration law and regulations. Since 2010, as many of you might already be aware, and as had been discussed earlier by some of the speakers, a few significant changes have been introduced to this program, which include the removal of the second medical examination requirement for the principal live-in caregiver applicant, the extension from the former 3 years to now 4 years within which the 2-year full-time live-in caregiving work can be completed, and providing an alternative means to complete the 24 months. That is by proving 3,900 hours of work within 4 years of arrival, but within a minimum of 22 months, and they can only count up to 390 hours of overtime work. And a third significant change that was introduced is the requirement for employers to pay all recruitment fees, transportation costs, WSIB benefits, and the blacklisting of delinquent employers. To date, however, no LCP employer has been included in the blacklist, nor have I seen any such blacklist in the first place. This law has become very tricky to enforce because most of the time, prospective caregivers are being asked to pay the recruitment fees and transportation fees by agents outside of Canada, hence beyond the reach of Canadian enforcement authorities or even our courts. So despite the fact that these changes have benefited many caregivers, there are still a whole lot of LCP participants who are encountering problems while being part of this program. For instance, a lot of live-in caregivers eventually fall out of status either because of the long processing delays of their work permit and permanent residence applications or eventual refusals of the same. These refusals may be due to the fact that they may either have performed unauthorized work, because as you know, live-in caregiving work does not pay much, so they're very much tempted to perform work in addition to live-in caregiving work. Or they may have committed misrepresentation for failing to disclose their true marital status, or have submitted falsified documents, or did not disclose the unauthorized work, or some other material fact. Another reason for refusal is the failure to complete the 24 months, yes, even within the extended 4-year period, which used to be only 3-year period. Why? Because because of the processing delays itself of their work permit extensions or renewals, or the permanent residence application, they failed to renew their work permits while waiting for the PRs. Inability to find another employer if they happen to leave their previous employer. Serious illness of the live-in caregivers. There has been a lot of caregivers who have been contracting cancer while still within this program, which could allude to the major stress that is brought to them by the difficult work, the nature of the work of a live-in caregiver. Or another thing is if they're forced to travel with their employers and work outside Canada, because work outside Canada of a live-in caregiver does not count towards the 24-month requirement. So that could contribute to why they are unable to complete the 24-month requirement, even within the extended 4-year period. Or again, another unfair reason for refusal is that a family member is eventually found to be either criminally or medically inadmissible. That is after completing the program and their family members undergo medical exams. the results reveal that their family member are inadmissible to Canada because of their medical condition could pose an excessive demand in the Canadian health or social services. So that doesn't only lead to the refusal of the dependent's permanent residence application, but the caregiver herself, who was able to complete the terms of the program, but simply because a family member is inadmissible, she also becomes inadmissible. And another recent trend that we have been seeing lately, a reason for refusal is financial inadmissibility. Why? Not because the caregiver has applied for or received social welfare assistance, but because the caregiver is bringing in a number of family members, but is unable to show proof that they have adequate savings or a well-paying job to be able to support those family members. So you can see the very unjust nature of such a refusal. So these grounds for refusal could have been avoided if the live-in caregivers are granted permanent residence at the outset, after they and their family members are screened, as is normally done for most other permanent residence applicants. So the LCP is clearly discriminatory in that the 2-year full-time live-in caregiving requirement not only encourages abuse and exploitation, but also prevents those live-in caregivers with inadmissible family members from obtaining permanent residence. In my view, this is tantamount to cruel and unfair treatment of these workers who undoubtedly contribute so much to the well-being of middle-class and wealthy Canadian families who have children, elderly, and disabled members. It is clear that despite the recent changes that have been introduced to the LCP, it is still causing great hardship to many of its participants and their families. Thus, there is a strong need for continuing advocacy efforts and in collaboration with all other temporary foreign workers and migrants experiencing similar difficulties to push for more meaningful reforms that will truly alleviate the sufferings of LCP participants and lead to a more just and humane treatment of these vulnerable workers. So I would now like to give the floor to Ms. Olayta for the second part of our presentation.
Thank you. I just want to express that I'm a little bit nervous because I want my presentation to be really conversational, based from my 28 years of experience. So I think that will be okay with you. I hope. All right, just to give you a simple background, why I have the courage to stand up and represent the voice. Once I was a domestic worker, now called live-in caregiver. Now living in Canada for 28 years, reunited with my family. But thank you. But the day in, day out of the struggles of many women always touches me and make me cry. So allow me to be emotional. We are self-organized. We never have been funded by any municipality, any province, or federal. We are here with raw courage because we believe that if we don't do something, nobody's going to help us. But I thank so much for the professional people like Deanna and good employers and friends, business community, who feel our difficulties because they are there to support us when we identify our needs. This organization is now registered as a charitable organization, which we are in debt because we use our own money. We go and work hard. And my entire life working in Canada, a big part of my income had been used to educate, to support, to be there for my fellow women. I have historical events we had the courage to come together and hold the first Ontario Caregivers Conference, where we have invited, as much as we can, Member of Parliament to listen to our stories, because we want them to see us. We want them to hear firsthand the stories of women who came together, around 200 caregivers. That was in the year 2011. And the legal workers came in with good health, because we cannot come in if we don't have that medical examination with police clearance and everything, good standing, high education, teachers, nurses, engineers, pharmacists, you can name it, accountant. Just with the hope that the employment that we believe is much better, because our country is failing economically. So out of that conference, it came out that thousands of women has been waiting for about 2 years for their work permit to come out. Just try to imagine, to put yourself when you are told you cannot work because you have no work permit in your hands. What do you do, my friends? Will you say your landlord, I cannot pay you because I don't have my work permit? Will you say to your stomach, don't complain because I have no work permit? Can you say to your children, don't get sick because I cannot work? So it came to the knowledge of our minister then that thousands of women were in this difficult situation, so we brought that result on the conference to the Parliament in Ottawa. And our minister acknowledged that he wasn't aware of that. And the conference actually took place September, so by December, around or less than 90 days after that, there was a release of more than 10,000 plus open permit. So it was a release for women who has been trapped, literally, in poverty and destituteness. So that was a rejoice, that was a celebration. We were encouraged because of that success. We were encouraged to have another conference, and that took place 2012. And then we were thinking, well, you know what? These are our experiences, these are our backgrounds, and we are working in an unsupervised situation, serving the families, looking after the newly born children, the toddlers, young adults, to the elderly care, and to the disabled citizen of Canada. And we are part building the nation, building Canada. And I thank our officials because they do acknowledge the economic contributions of people who come and work here in the temporary foreign worker. So we made another petition that because we were classified, live-in caregiver is within the temporary foreign worker, and the live-in caregiver now was just, I don't know if that was really in the legislation or just a pilot project that they are given pathway to permanent residency. It's a special program. So it's a special program. It wasn't written in the legislation, so it can change anytime. So we thought that when we are classified, instead of low-skilled, maybe they will listen to our appeal, that our position will be reviewed and we will be part of the skilled workers. So therefore it goes with the petition that we should be given a permanent residency at the outset. That is to just put a stop or healing on the root of abuse and exploitation. So that was in the 2012, and what is intimidating now, what's keeping me restless, upset, angry, and upside down because of the many things that are being submitted right now to change the temporary foreign worker. And you have heard about the moratorium of the temporary foreign workers, especially affected are the ones working in the restaurants. So there are so many exchange words between the different policymakers and our public officials. But at the same time, we women are trembling. Now, we don't know what they're going to do with the live-in caregiver, with thousands of women with their families, because those who have been trapped with the open work permit are automatically affected with the release of their permanent residency status. So that is our status right now. We don't know what's ahead of us, but we continue to pray and we continue to educate ourselves and to strengthen ourselves, build that confidence that we are able to deliver the message. Thank you.